Okay, so we're about to get started for the afternoon session. First up is going to be a conversation from Jesse Erlich regarding IP rights under SBIR and beyond. And let me introduce Jesse. He has been a partner at Burns & Levinson in Boston since January of 2006. He provides advice on patents and other forms of intellectual property, licensing, and government-related matters such as government contracts, SBIRs, STTRs, intellectual property, licensing, and technology transfer. In addition, he is involved with preparation and prosecution of both U.S. and foreign patent applications. Jesse is a frequent contributor to publications in the fields of intellectual property and technology transfer and has authored and co-authored numerous articles on books on the subjects. He is a registered patent attorney with the United States Patent and Trademark Office and the Canadian Patent Office. So please welcome Jesse Erlich.
Thanks, yes. While we're waiting for the slides, I'll just I want to mention about the allowable costs for patents. I wanted to go over that. I commend this gentleman over here for having that taken out as an allowable cost, but don't think that you will always get patent costs as allowable costs. Under 31-20530 of the FARs, there are two criteria. One, the first criteria is to get a patent cost as being an allowable patent cost, it must be a requirement of the contract. And then if it's a requirement of the contract, if it's a patent application filing cost, then it would be allowable if it also is required that the government's rights in that particular patent are required, such as a confirmatory right. So there's two sections, and I've had clients who have been fortunate in getting their patent costs considered allowable, but the audit agencies can look at it two ways. Number one, they may say, yes, it's required. On the other hand, they could say that electing to take title to a patent by the contractor is not a requirement because you can still have the SBIR contract without getting a patent on it. And therefore, the government wouldn't get any rights, but neither would you. So I think it's sometimes wise to try it. I would check with your accountant, especially an accountant who is very well versed in government contracts. And because if you get stuck with an audit, that's probably the last thing you want to get stuck with. I always say the government is in a situation when you have to end up with a suit or some kind of dealings with the government that involve lawyers and litigation. The government prints money. So when they print money and they have their own attorneys, you're behind the eight ball in that situation. So I commend the gentleman for getting those allowable costs, but don't, just like Jim was saying, it's not something that you can be guaranteed to get. And if you don't get it, or you aggravate the person, such as the people with NIH, then you may find yourself on the short end of getting other SBIR contracts. And that's not the law, but it's just the reality of life. I want to point out also my experiences in my past life was I was Chief Patent Advisor for the Air Force, so I have had quite a bit of experience dealing with the government from the government side, and then I was with Perkins, Smith & Cohen, and then later we merged with Burns & Levinson, and Burns & Levinson is an all-purpose firm, so we not only do patent work, we advise clients in their business dealings as well as mergers, acquisitions, and so we kind of look at everything when we look at a client and not just should you file a patent, should you not file a patent, because the most important thing for SBIR recipients and small companies is you want to leave yourself enough money so that you can produce the product that you're trying to get all these patents in. So a patent is nice to have, but if you have no more money left, then that really doesn't serve you a purpose. So there's a little bit of balancing on what you're going to file on and what you're not going to file on. I'm going to bring out the fact that today my talk is going to deal a little bit with some of the ramifications and some of the requirements that are necessary, how you can maintain your rights to your patents, because the SBIR program is a great program. And before going into those things, I want to point out that the problem with dealing with the government, and I have clients coming to me and saying, you know, I don't want to deal with the government, I don't want to apply for the SBIR grants, because once I do, I get involved with the government, and then I have to give the government certain rights, which are these confirmatory licenses, and then the government can use that, and possibly they may give it to somebody else, and then I might have a patent, and then I'd like to stop the government from using my patents. Well, the first thing to realize is the government is king. The government can practically do whatever they want to do. So whether you give the government a confirmatory license or whether you don't give the government a confirmatory license because you did all of the patenting work at your own expense, if the government wants to use your patents, they can do so. They're not like the private sector. In the private sector, you can get an injunction against somebody, you can stop somebody from infringing upon your patents. The government goes ahead and infringes your patent, and then you have a recourse to get a royalty from the government. But that recourse is a suit in the Court of Claims. And most small companies, and even large companies, find it difficult to sue the government. So if that's the way that you're going to get paid as far as a royalty goes, and that's your biggest concern, that I wouldn't let that stop you from applying for SBIR contracts. Because if you have technology which the government wants to end up giving to somebody else, in the sense that it's another procurement contract, you're going to have difficulty stopping them. That's the realities of life with the government. The nice thing about getting an SBIR contract is that if you get that SBIR contract, now you're in line for a sole source. So that's probably one of the most important facets of getting SBIR contracts, outside of getting some money from the government as well. I'm just going to quickly go through phase 1, phase 2, and then phase 3, because that was all explained earlier. And what I have in my slides is basically what the amounts of money that were eligible under phase 1 and phase 2 prior to the reauthorization. Jim did a great job in the reauthorization to point out that one of the big aspects of reauthorization is not only that we don't have to worry about these continuing resolutions, is the fact that the amounts of money have been increased, and that's a very important factor. The other part that I think is very important is phase 3. Now, I heard on one of the panels that maybe the government should just call it commercialization, but the nice thing about phase 3, if you are in phase 3, and phase 3 means that that particular aspect of a contract, whether that contract is with the government because that's considered commercialization, or with the private sector, if it derives from or extends or logically concludes the efforts performed under a prior SBIR funding agreement, then the rights that you've obtained under the SBIR funding agreements that you have in phase 1 and phase 2 carry over to phase 3. And that means the protection of data rights, which are very important, and which the government can keep secret for you for at least 4 or 5 years, and then with each phase another 4 or 5 years. So cumulatively, you can get many, many years out of that. In addition, you are a sole source for the government, and you will find many large companies at SBIR events. Not so much. You say, why are they there? They're not going to be getting SBIR contracts. They're there because they would like to be the subcontractor to you, the small company, as the prime. Because in most situations, the prime can't fulfill, for example, a request for $10 million worth of widgets. But you could get a large company to help you fulfill that contract, so then they become the sub and you become the prime. Kind of opposite to the way it is in most procurement contracts. So the phase 3 is a very, very important part of the entire SBIR process. Now, there's certain regulations and rules and regulations that you must follow, and I always say it's very similar to this elderly couple who was sitting at home one day, and I can use elderly because now I'm elderly. Before I couldn't tell this story. And the wife said to the husband, you know, it'd be nice if you got me an ice cream sundae. And I'd like an ice cream sundae with vanilla ice cream and chocolate sauce and whipped cream and nuts and a cherry on it. And hopefully you can go out and get that for me. So the husband starts, you know, like most husbands do, he starts walking out the door ready to get that ice cream for his wife. And she says, you know, you better write that down because you're not getting any younger, and I really asked you for a lot, so therefore, why don't you write down what I'm asking for? I want vanilla ice cream, and I want whipped cream, and I want chocolate sauce, I want nuts on that, and a cherry. He says, don't worry, I remember everything. I may be a little older, but I can remember everything, so I don't have to write anything down. So he goes out, and about 20 minutes later, he comes back, and he hands his wife a bologna sandwich. And she looks at him and says, see, what did I tell you? You should have written it down. Where's the mustard? And the reason why that's relevant is because you have all of these written requirements that the government wants from you. And they want from you, number one, because they're mandated by law, they're statutory in many instances, but also it allows people to remember exactly what type of arrangement they entered into. Because if you didn't have written contracts, people would forget. And just like the woman forgot and the husband forgot, the government tends to forget, and so do other people that you may enter contracts with. Now, one of the things is that what happens in a government contract in an SBIR, and this pertains to all government contracts, except there are more advantages to the SBIR contract, in that you have inventions and you have data. And a lot of individuals will confuse the two and say, oh, I need a confirmatory license to the government in this data, but that's not the case. Or I have an invention, and I have to say, is it a restricted invention, a limited rights invention? And that's not the case. There are two certain sets of rules and regulations, one that pertains to inventions and one that pertains to data and any software. So those are separated. Inventions are statutory. The government what that means is the government has a certain set of rules, and you must abide by those rules. When you deal with data, that's negotiable. When you sit down and you deal with either deliverables or data that you might have before the contract, you sit down and negotiate that with the government as to what kind of rights the government has. But the beauty of the SBIR world is that when you have data, that data must be kept secret by the government for a certain period of time as long as you mark it properly, and that's what I'm going to be going into. So what is the definition of an invention? Well, an invention is defined as it is defined in any type of law. It's a discovery that you may have. The big difference in government contracts is that government deals with a term called subject inventions. And you've probably seen that, and you say, oh, what does that mean? What's the difference between a subject invention and an invention? And this doesn't make any difference whether it's under the old patent laws or whether it's under the new American Invents Act. In fact, I'm not going to really go into that because when it pertains to the SBIR contracts, there's going to be very little difference. Where it's going to take into effect is when you start dealing with the patent office. But under the government contracts, it's really whether it's under the old law or new law, it's not going to change very much. There's still, as I always say, the new American Invents Act, which talks about the first to file rather than the first to invent. And the interesting thing is it's kind of a hybrid system because this grace period of 1 year is still going to be relevant under the American Invents Act for the inventor themselves. So therefore, there's going to be relatively no change with respect to SBIRs. But what's interesting is that when you talk about subject inventions compared to how an invention is defined in the patent laws, an invention is defined in the patent laws when an invention is made, it's conceived, and then it's reduced to practice. And that defines an invention. The making of the conception of the invention when you link it with a reduction to practice. But in the patent law, a reduction to practice takes two forms. It takes one form in which the reduction to practice is either actually reduced to practice or it's constructively reduced to practice. That means you can actually file a patent application in the U.S. Patent and Trademark Office and never have actually reduced the invention to practice. So you have the conception, and it's linked with a constructive reduction of practice, which is the filing of a patent application. So those two things are considered to make an invention. But when you deal with the government, they change the rules a little bit. They come out and say that a subject invention means that the invention was either conceived or first actually reduced to practice under the government contract. So they separated them a little bit. Well, you know, when you conceived it, if you clearly conceived it under a government contract, it's made under the government contract, and therefore it's part of the government contract. But the question comes in when you first reduce an invention to practice and you do it under a government contract. That means that becomes a subject invention. And so therefore, even though you may have filed a patent application before the government contract, with your own money and your own expense, and you filed it that way, now what has happened is you could have filed a patent application, you've actually obtained a patent, and now you get an SBIR contract, and in the realm of the SBIR contract, you reduce the invention to practice. It all of a sudden becomes a subject invention. And that subject invention means that it was made under the government contract, and there are certain rights that are going to go to the government. So what I wanted to make clear to you is that just because you've obtained a patent, or just because you filed a patent application prior to a government contract, doesn't mean that that invention is not a subject invention. Now, the other part of it is computer software and data. And data is a little different than inventions because data is not something that's patented. It's sort of recorded information that you might be giving to the government. And sometimes you give to the government under the government contract, and sometimes you have it and you bring into the government contract your own data, which is your information. And think of it a little bit like trade secret information, know-how information that you might have that is not going to be patented. Copyrights, computer software is a little different because in computer software you could have data, but you can also file a patent application in computer software. And the government through all these years have never really figured that out because you could give the government data pertaining to your computer software, but you could file a patent on that same computer software and protect it as being an invention. And then the government would get only a very, very limited rights in that situation. They would get a confirmatory license to use it for governmental purposes. But what do you have to do when you have an invention under a government contract? First of all, what's nice about the SBIR program is that you can have title to your inventions. So you can own your inventions, the government takes no equity in your company, and they give you money. And not only do they give you money, they give you a sole source. So it's a great program to be involved with because you get to be owner of your inventions, you get to get money from the government to develop a particular product, and then the government says, if we have a procurement in this particular area, we're going to, it says may, but it means maybe 90 or 95% sure that you're going to be the company that's going to get that procurement contract. That's pretty good deal. And that's why I'm very, very thrilled that the government has, that the Congress and got together and they actually reauthorized this particular SBIR program because it's a great advantage for small companies to get into the business. And what it does is it certifies that you have something worthwhile for maybe another large company to give you other funding or angels or eventually venture funding as well. So what happens is, since the contractor, and I call it the contractor, which in this case would be the SBIR recipient, can retain all the right, title, and interest throughout the world, that means even in foreign filings, to each subject invention. However, the government gets one thing. The government gets what's called a confirmatory license. That license enables the government to use your invention without paying you royalties for governmental purpose. If the invention is yours and it's outside the government's contract and it's not a subject invention, then what happens is that the government can use it. Unfortunately, what did I say before? You've got to sue the government to get your royalties. The government just doesn't give you royalties or take out a license prior to issuing a procurement contract in which they may give your particular invention to someone else, to another company. The reason for that is, and it's kind of a funny reason, not only because it's difficult to determine if in fact that patent is being infringed, there are many reasons why that patent could possibly be invalid. So it's a real big legal process. The other one is that if the government were to give you a royalty up front, that money comes out of the agency. If you sue the government, that money comes out of the entire general fund. So no agency is going to reach some kind of settlement with you knowing the money's going to come out of that agency itself. So they're going to say, well, let's go to court and find out whether or not the government has infringed your patent. So that's another reason, as I said before, why the SBIR program is so good. So the government gets a royalty-free license to use your invention for governmental purposes. Doesn't mean you can't make a profit. It just means you can't get an additional royalty for them using your invention because they paid for that invention under the government contract. And what's also interesting when you think about it is, what does that mean that it's royalty-free? It kind of means that it's a little bit of a discount. It means that if you went and took that invention and licensed it to someone in the private sector, they'd pay you a royalty. Well, since the government doesn't have to pay you that royalty, it's a little bit of a discount of what you would make as a profit. Still not a bad idea. Now, if you determine that you do not want to take title, you say, look, this invention isn't worth it to me. Or you may say, well, it's just too expensive to patent it. You do not have to elect to take title. And if you elect not to take title, and you do not take title, the government is the owner of your particular invention, if they file a patent application on it. And if they go through the whole process and get a patent, then you would get this royalty-free right to use your invention. They wouldn't buy you from using your invention in the commercial sector, but it would be a royalty-free right. However, it's a revocable royalty-free right. If the government felt that they had opportunity to commercialize your invention and you were not commercializing the invention, then the government could say you're not even entitled to a royalty-free right to use your own invention. However, since you didn't file, that invention probably isn't that valuable anyway. But you should realize there are two ways when you deal with the government with respect to inventions. Those in which you elect to take title and those in which you do not elect to take title. And that goes back to allowable costs, because the rule says that if you are required to get this patent protection, then the government must say it's an allowable cost. The question is, under an SBIR contract, is it truly a requirement? You can still get an SBIR contract and not file for any patent application whatsoever. So sometimes the audit agency will come back and say, this is not a true requirement of the government. If you get it in the statement of work, and the statement of work says you must file a patent application, then it would be an allowable expense. And so that's something that you want to talk over with your accountant who's specialized in dealing with the federal government, because you do not want to get audited. It just isn't worth it for a little company to get audited. Now, what happens also when you're going to file this patent application? There are certain things you must do. You must identify to the government any publications or offers for sale or public uses of the subject invention. Where the American Invents Act is going to come in and where they're probably going to change this, they're going to say you must also tell the government if there are any disclosures of your invention to anybody, because that could act as the start of a statutory bar period to yourself. And the reason publications become even more valuable now is because under the first to file applications, if someone had a publication before you filed, that publication could stop you from getting a patent. So remember, you must report this to the government. And then what's another important thing? This is something that's very, very important if you never get an SBIR contract. And that is if you have a company, to make sure that your employees are under a specific employment agreement. And in that agreement, you want to make sure, since you're paying that employee a salary, that that employee gives you title to the inventions that the employee makes while that employee is working for you. Why is that important? It's important twofold. Because if you have a company and your employee does not give you title to that invention, by law in the United States, the inventor is still the owner. So the inventor could walk off with your invention. So you want to make sure, if you're going to pay that employee to invent things in your company, that you, the company, are the owner. But what's important under the SBIR, under government contracting, is that, remember I mentioned to you, there's such a thing as called a confirmatory license, or a license for the government to use your invention for governmental purposes. But if you don't own that invention, you can't give the government the royalty-free license. So if you don't have an employment contract with your employee transferring ownership to your company, then your employee owns the particular patent. And that employee is not in privity with the government, and therefore the employee has no obligation to the government. And when the government comes to you for that royalty-free license, you say, uh-oh, I don't own this patent anymore. It's not my patent. And the government said, you've just violated your contract. That's a breach of your contract. You said you would give us a royalty-free license because of law, because of statute, on any inventions that are made under that particular government contract. So I'm saying twofold reasons. One, to protect your company, you want to have ownership of all the inventions. And two, if you're entering into any government contract, you want to make sure that you have ownership of those particular inventions. In fact, just to show that it sometimes backfires, even large companies like, even large universities like Stanford University made a mistake like that recently. And what happened was there was an inventor that they had that ended up giving ownership not to Stanford University, but which turned out to be Roche. And when Roche got sued by Stanford for patent infringement, their defense was, wait a minute, we're an owner of this patent, you can't sue us. So it shows you that even large universities sometimes make a mistake themselves in not making sure that they get the particular ownership rights to the inventions that are made under their, in this sense, under their employment agreement. Now, the other thing that's important, when you file this patent application, let's say you change your mind and you decide you're going to abandon the patent application, or for whatever reason there are office actions that come in, or maintenance fees that are to be paid. If you're not going to continue with the prosecution of that patent application, or you're not going to pay those maintenance fees, then you have to notify the government, because the government has the right to do so. Again, it's a cause for breach of contract if you don't do that. So it's very important that you keep the government informed of everything that's going on in this patent application if you don't continue prosecution. If you continue prosecution, the government doesn't want to know because it's yours. And again, you want to make sure that you agree to execute or have executed and promptly deliver to the agency that you're dealing with all instruments necessary to establish and confirm certain rights to the government. If you decide you're going to not pursue your patent, then you still have to sign ownership over to the government. If you have a confirmatory license, you want to make sure that's done. So there's certain other requirements that are required under any government contract, not only SBIR government contracts. And you have to put something, have your patent attorney who would know this, put this at the beginning of the patent application, that the government has certain rights in your particular invention. That's to put people on notice that the government is involved. And if you happen to miss any of these things, it could be disastrous, because the government could come back and ask for title to your invention. Now, some of these items can be corrected. There's timelines, and I'll show you what those timelines are in a couple of slides that come after this. But what's interesting is that people forget, and they make mistakes. The government is generally very, very lenient in this area, because the government doesn't want to take ownership of your patents. They would like you to have ownership and for you to go out and commercialize it and make money and eventually pay taxes, and everybody's happy. But sometimes things are forgotten, and the best thing is to let the government know that there was a mistake made. It was an unintentional mistake. It was just a mistake made. Similar to what Jim said, where he told the person who forgot about indirect costs or profits and went back to the government. The government is not as mean as one may think it is. In these situations, it's trying to help you, because the more it helps you and the more money you can make, the more taxes you pay. So the government has an ulterior motive of why they want you to be successful. And they really don't want your patents. But they will take it under certain circumstances. In fact, there was a case recently, well, not recently anymore, but a while back, where someone forgot to do one of these things. And they did a lot, but they forgot to elect to take title. They filed the patent application, and they went and even put the statement at the front of the patent application that the government had certain rights, but they forgot to fill out a particular form. And I was shocked when I saw that the courts ruled in favor of the government and said that the government now owned that particular patent, because that's generally not the case. I've had cases where 2 years after the fact, a client came to me and said, gee, I think I forgot something. We went back to the government, corrected that, and everything was fine. So I said, there's got to be more to this story, because I can't see why the government would go out of their way to take ownership of this particular invention when I've never even heard of this before. And I gave this talk at a place, and in the audience was the patent attorney for the Navy at that time, who said, I'm the patent attorney who went after those rights. And so I said, gee, you got to tell me, it's got to be more to this story. It turned out what happened was that the company that they dealt with was giving the government a real hard time. And they neglected, because they didn't think there was a government employee that was an inventor. And the government turned out and said, yes, we have an inventor, but there was a big argument and a big fight. The inventor for the government was never listed. Had he been listed, the government would have had partial ownership. The company would have had partial ownership. But because they didn't list the government inventor, the government didn't have full ownership. And they said, we're going to get him. It turned out they were lucky, because this company made a mistake. And once they made a mistake, they went after it, because now they ended up with full title to the invention. The company got nothing. So what I'm saying is, don't fool around with the government. If they're mad at you, they can go after you. And like I said, they have an endless supply of money, which most companies don't, even large companies. So just be careful when you deal with the government that you stay on their right side. And you're lucky you have someone like, John here today, and he's easy to get along with, and he's trying to help you. And he was right when he said today he was here to help you, because he is here to help you. And most people that I've dealt with in the government, including myself back years ago, we really tried to help the people that we dealt with, because we are public servants, and that's our goal, is to help these people, and in particular, the SBIR recipients be successful. Because SBIR recipients that are successful, when the agency reports to Congress, how well have you done? They would like to see success stories. So don't be scared about dealing with them. Ask them questions when your period of time is there, and in most circumstances, you'll find them very, very helpful. These are the charts that set forth the various timelines that you have in order to do things. And if you notice, there's a statement in here which says that you have to report things at least a certain number of days prior to the end of a statutory period. That's because a statutory period, like the 1-year period in which you have to file a patent application after you've had a printed publication or a public use, what happens in that particular situation, if you don't file your patent application, then you're barred from getting a patent. So there's rules and regulations which will prevent you from getting a patent. And now with the America Invents Act, when in 2013, when it's first to file, if there's a publication that comes out prior to your filing, that could be a bar against you getting a patent. So make sure you talk to your patent attorney about that situation. Yes. Right. If you file a provisional, then you want to make sure that within 1 year from the date of the filing of the provisional, you file your patent application. If your provisional expires before you file the patent application, you're out of luck. But if you file your patent application within 1 year of the filing of the provisional application, then you get the earlier filing, the earlier date as what they call a priority date. And then, as you can see, they say the filing of a patent application or a provisional. It says non-provisional or a provisional application. There's a big dispute going on now on the filing of what they call a PCT application, which is a Patent Cooperation Treaty application. That files your patent application in virtually every country, and then you have to designate countries, and it costs a lot of money to do so, but you can also designate the United States if you want to. For some reason, many agencies do not accept the filing of a PCT application as the filing of a patent application in the United States. I maintain that's totally incorrect because the PCT application acts as a priority date as well and is considered to be the filing date of your application in every country that's listed as the PCT, a part of the Patent Cooperation Treaty. But it took the Patent Office 12 years, not the Patent Office, but it took the government about 12 years to recognize provisional applications, so maybe it'll take them about another 12 years to recognize PCT applications. So I'm sure that's going to be changed. I've recommended a change already, but it probably will take a long time before that takes place. And as you can see, you make sure that you also elect to take title. I noticed on the DD 882, which is Department of Defense, which I'm very familiar with, they ask you if you elect to file a patent application. What that means is if you file your patent, elect to file a patent application, you're in essence electing to take title. But there's no box that says, I elect to take title. And I always tell my clients, just write it in, that I elect to take title, because one of the requirements is a written election to take title. And I'm not even sure that iEdison, which is the form, which is an electronic form of claiming your inventions, if they even require a specific written document that says, I elect to take title. So just do it. You're better off being safe and putting it down than to not do so. I have here also a timeline for large companies. I just threw this in to show you it's exactly the same as the SBIR timeline for small companies, except it shortens a lot of the time periods. So there's another advantage of the SBIR contract. And what happens if you fail to do some of these things? What happens is that the government may, and it's a may, after written request, take title away from you. Why that's important is that if for some reason you don't do some of these things, and it comes up later on in court, that's not the time to start correcting stuff. If you're going to correct it before you end up in court. Because once you end up in court, for whatever reason, you can't start correcting things. And we had a client who was sued by someone, and we found out that they made a mistake and they forgot to elect certain things. They forgot to fulfill some of the requirements of the contract. So we brought up the fact that they didn't own that patent anymore, that the government owns it. We told the judge we're going to bring it to the attention of the government. They're going to own it. That company didn't own the patent. And because they didn't own the patent, the judge threw out the case because they felt that the patent holder, supposed patent holder, didn't have the right standing. They didn't have the standing to sue because they didn't own their own patent. So it's always very important to make sure you go over with your attorney or whoever is advising you on this, that you fulfill all the requirements that the government has in their SBIR contract or any government contract. So it's not as simple as the law may seem to some people, which says, oh, you get a government contract and you have title to your invention. You have to do certain things to take title to your invention. Now, what if you're a subcontractor? One of the nice things about being a subcontractor, and this just changes a little bit, because let's say you're a subcontractor on an SBIR contract, you're a subcontractor and any contractor. The subcontractor gets the same rights as the contractor when it comes to inventions. And that's a direct flow down to the subcontractor. So therefore, if you hire a subcontractor to do work and you don't have some type of agreement with that subcontractor can own title to their inventions and completely can leave you out. So it's very, very important to have agreements in place with all of your subcontractors. Now, what's also interesting is you can't force a subcontractor to give you any kind of ownership. I had a case where a client came into me and says, I'm a subcontractor with this large company, but they want ownership to any patents I make. I said, they can't do that. It's against the law. No one can force a subcontractor on the grounds that they're going to give them a subcontract to give you that particular main or prime contractor ownership to their patents. That's a direct flow-down clause. That subcontractor acts as if that subcontractor is a contract for purposes of inventions. So just remember, if you have any subcontractors, put agreements in place. And one way to avoid the fact that you're forcing them to give you title is you can buy the title from them. You can license from them. But just make sure that you have certain interests in that patent, or you may not have rights to their patents whatsoever. So when you're out in the commercial market, it could cost you a fortune to try and get some rights from them if you intend to commercialize your particular technology. Now, what happens here? The subcontractor will retain all the rights as if that subcontractor was the contractor. So think of the subcontractor, when it pertains to inventions, as being the contractor. Now, another thing that's very important is that when the contractor goes out and manufactures or assigns, or let's say licenses exclusive rights to someone, one of the stipulations that the government has is that the manufacture of that particular product must be substantially in the United States. Well, I'll tell you, there's not very many things made substantially in the United States anymore. There's not many things made in the United States anymore. So consequently, the government will grant waivers to this. So let's say there's some components that you need that are not made in the United States. You just ask the government for a waiver, and they'll grant those waivers because they know themselves that it's tough to get a whole product manufactured in the United States anymore. Now, the fiat margin rights. That's another area where clients come to me and say, I'll never deal with the government, because even though I get ownership to my patent, the government can come in, march in, and take it from you. First of all, as I said before, if the government wants to take your patent anyway, and they want to give it to somebody else, if it's for a government contract, they can do it. You can sue them, but they can do it. But in this particular situation, there are certain circumstances where the government can come in and take your particular invention and do whatever they want with it, if they want, if that particular invention was made under a government contract. But you know what? The government doesn't do it. I don't know of a single case that came to conclusion where the government has ended up marching in and taking anybody's patent. The reason is they don't want it. The only reason they may want it here is if there are some specific reasons, such as you're not commercializing your invention. Well, but the government warns you and says, you know what? We have a company that may want to commercialize your invention. So then you start thinking, well, maybe it's a good idea if I commercialize that particular product. So you can correct these things. They don't just come in and take it from you. They give you an idea of why they're coming in to take it and why they want to take your particular invention. If there's specific health reasons, or for example, let's say you came up with an AIDS vaccine and you just didn't want to market it. And the government said, this is for the benefit of the health and welfare of the people. We've got to have this, and so we're going to allow somebody else to go ahead and do it. But you know what? If there's somebody else that's going to do it, maybe it's a good idea that you did it. So there's always a reason of trying to avoid this. And I don't know of a single case where the government has come in and actually marched in and taken over somebody else's patent for that particular reason. Now remember, I talked to you about data. That's a great part of the SBIR program. And the reason it's such a great part of the SBIR program is if you have developed data under a government contract, the government's got to keep that secret. In fact, they can't even use that data in another procurement contract. And that secret remains from 4 years to 5 years for each phase of the government SBIR program. So you can stretch this thing out, phase 1 for 4 or 5 years, phase 2 for 4 or 5 years, phase 3 for 4 or 5 years. It's a great thing. It's not available under any other type of government contracts. So be sure to understand that SBIR data rights are really important, and I'll show you certain markings. You have to mark your data. You can't just assume that that data is going to be your data. You have to specifically mark the data, and you have to mark it the way the government wants it marked. You can't just randomly mark that data in any other way. You have to mark that data specifically the way the government wants it marked. And the government they're required to protect your SBIR data rights developed. And they must insert in these particular SBIR contracts that your particular data falls under data rights. Now, the interesting thing is data rights are not inventions. I talked to you all about inventions. Those are statutory. Those fall under all contracts. These data rights are negotiable when you deal with the government as well. as to what type of rights you're going to give them. Are you going to give them unlimited rights in which they give it to everybody? Make sure that you negotiate your data rights before the contract starts, not after you're in the middle of the contract and say, uh-oh, now I'm going to negotiate my data rights. These data rights are, in fact, negotiable, and they carry through to phase 3. So therefore, if you have specific data and it ends up in phase 3, keep pointing out to the government that this is developed under an SBIR contract, and I'm entitled to specific SBIR data rights. And as I said before, the SBIR data rights continue to be protected from the date of delivery of the last deliverable under an award. That's a long time. And any SBIR data rights that is protected and referenced under a subsequent SBIR award, then they remain protected. So you get many, many years of protection of data. Now, there's two types of data, and there was a spelling error here. I gave this to my marketing department, so they changed markings to marketing, so you can see what's on their mind. That, where it says marketing in a couple of instances in here, that should be markings. There's specific markings which the government require that you put on. And the first thing is that if you develop data under your expense, and again, this is a little different than inventions. Remember, inventions, I talked about conception and actual reduction to practice. Data gets marked. That's like information that you're giving out. So if you have specific data that you're going to be using in a government contract, but they're your data that you do not develop under the government contract, you developed it outside the government contract, and they call that a private expense, you can exclude that government from giving it to anybody. So, but you want to mark it properly. And this, you'll see this in here. And this is an area you want to talk to your attorney that's representing to make sure that it's marked properly. You want to talk to your contract administrator to make sure that you have the proper markings on this. That is very critical, because if you omit those markings, then it becomes government unlimited rights to use it for whatever purpose they want. And there's little statements that you put in, you identify it. And if it's an SBIR data that you may have developed earlier, then you have to mark that as well. But I'm talking here about information which is given to the government with limited rights. Limited rights meaning the government can only use it for that particular contract that you're in. It's your data, it's your proprietary information, and no one else can use it. And there's a chart that the government gives you, and you'll find that, and it's available, it's publicly available, and you put down the basis, you put down what your data is. I just summarize it. I mean, you don't have to put every word for word, but give the idea of the government of what data that you're going to be putting in there. And then it could be summarized in a very nonchalant way, but point out that you're maintaining limited right, that the government's only getting limited rights to that data because that data is yours and it was developed under private expense. Now, if it was delivered under the contract, normally you're negotiating with the government and you say to the government, well, I'm going to give it to you for this particular contract, and then over a period of time, maybe eventually the government will start saying, well, we want unlimited rights because this is a deliverable under the contract. SBIR changes it all. Even though you develop that particular data under the government contract, they have to keep it secret for you. But you got to mark it properly. So again, look at this is data that's delivered under the government contract. You want to make sure there's an SBIR notice on, and that notice carries through to other contracts. If it goes to phase 2, it goes to other contracts. It could be a non-SBIR contract. You tell them, this is SBIR data that I'm delivering to you, and it's SBIR data with certain limited rights that I have, that you don't have the right to just give it to whoever you want. After the expiration period, then that information becomes unlimited, and the government can basically do whatever they want with it. But it's a long time, and generally speaking, that data is probably not worth that much after that period of time anyway. So I just wanted to point out to you, this is a great program. The SBIR program I found is one of the best programs available. There's no equity involved in this. The government doesn't take equity in your company. The government gives you money, and then on top of it, they give you a procurement. How much better can you get? I mean, and you know that the government has a chance of giving you a procurement contract because one of the criteria in their solicitations is that the government has a need for this. So, I mean, think about this. It's really worth going after this. I don't know how many, there's quite a few people here that have had an SBIR contract, so I'm sure they can tell you that this is a pretty good deal. It's not so much the money. Phase 2 is very good, but think about it. It gives you credibility. If you go after further investments, you can increase the amount of money that you're getting from the government. Various states, including the state of Massachusetts, I'm not familiar with Vermont, Massachusetts is working now out a program where they're going to give SBIR recipients more money if they have SBIR contracts. And the success of SBIR companies is much greater than companies that have never had SBIRs, because they've got the credibility. Then you can get venture funding, so it's a really good deal. And just make sure that you protect your intellectual property. I'll be here. I'm going to stay a little later, after 4 if you have any other specific questions, and I'm always available. In fact, I'll leave some cards over there in case you miss me, in case you do have some questions. So thank you, and I don't know if there's any questions now that you have. We have a couple minutes. Yes.
With a research institution.
You mean with having nothing to do with the government? You mean a research institute that's like a university or something? Right. You have, that's all done by contract. And even the government, in a way, is done by contract, because as I mentioned before, data does not fall under statutory provisions, meaning that statutory means you can't change the invention rights clauses. That's the way it is. But when you're dealing with data, they give you various options, so you negotiate it. The same way you negotiate with like a university or a company or whatever it may be, and you want to make sure that you have ownership to this information. You might put it under a non-disclosure agreement. Say, we're giving you this information under a non-disclosure agreement to be used in this particular instance. So that's, you can only do that by separate agreement or part of the agreement that you sign with the company. And in most agreements that you sign with the company or universities, there's stipulation as to what happens to inventions and what happens to data.
Thank you.
Yeah.